Good afternoon. Thanks everyone for joining the South Florida chapter of the American Constitution Society for our annual 11th Circuit Year in Review. As you know, ACS is a nonpartisan, nonprofit 501c3 dedicated to promoting education and ideas about the rule of law, equal justice under law, and diversity. Today, we're honored to have a panel of guests to talk about the 11th Circuit. And we're so grateful that Dean Erwin Chemerinsky joined us. Erwin really needs no introduction, but he, as many of you know, he is the Dean of the UC Berkeley Law School and the founding Dean of the University of California, Irving School of Law. He was also a professor at Duke and the University of Southern California. He's written 14 books and more than 200 law review articles. We also have 3 appellate lawyers who know the 11th Circuit well and clerked on the court. Tania Galloni is the managing attorney in Miami for Earth Justice and previously was managing attorney at the Southern Poverty Law Center. A graduate of Yale Law School, she clerked for Judge Rosemary Barkett on the 11th Circuit. Dwayne Robinson is a partner at Kozyak, Tropin, and Throckmorton in Coral Gables. He is a magna cum laude graduate of the University of Florida Law School, editor-in-chief of the Law Review there, and a clerk on the 11th Circuit for Judge Edward Carnes. And finally, Freddy Funes is an appellate lawyer at his own firm, Toth and Funes in Miami. He's a summa cum laude graduate of the University of Miami and a graduate of MIT, and he clerked for 2 judges on the 11th Circuit, Judge Adalberto Jordan and Judge Stanley Marcus. If you all have questions during the presentation, please put them in the Q&A box and we will try to address them as time permits. I also wanted to let you know that we did prepare a discussion guide, sort of a cheat sheet to help you with the cases and what we're going to be talking about. And you can access that in the link that's in the chat box. So with that, I want to spend a few minutes and talk about some pretty significant changes on the 11th Circuit. During the last presidency of Donald Trump, 6 of the 12 active judges on the court were appointed by President Trump. And it really created a sea change in the court, which was already a very conservative court and potentially now has become an even more conservative court. And we're just going to briefly talk about those 6 appointments on the court. And I'll start with Judge Kevin Newsom. Judge Kevin Newsom is approximately 49. He's from Alabama. He's a former clerk to Justice Souter on the Supreme Court and Solicitor General of Alabama. And he is filling a seat that was originally a seat that President Obama was going to fill. President Obama had nominated a district judge in Alabama who would have been the 3rd African-American on the court, but the Republican Senate never took up that nomination. And when Trump won election, he appointed Judge Newsom. Judge Newsom is a pretty engaging writer. He's known for a very informal writing style, and he's also known for writing a lot of concurrences. In fact, he has in 4 or 5 cases just in the last year written the majority opinion in a case, and then also written a concurrence in the same case to kind of expand his ideas on the law. Dwayne, do you want to tell us about some of the other Trump appointments to the court?
Sure. First, thank you for inviting me. Very happy to be here. I want to talk about Judge Robert Luck. He's one of the new appointees to the 11th Circuit. Judge Luck was a University of Florida graduate who, before joining the 11th Circuit, served in the Miami County Court, Circuit Court, 3rd District Court of Appeal, and then the Florida Supreme Court. The running joke here in Miami is that his rise was meteoric. As far as a practitioner, as far as a judge, Judge Luck is known as a judge who's very well prepared, who scans the record probably better than a lot of practitioners. And if you have OA, he's on your panel, be prepared for a very hot bench. I think that as far as the new judges goes, he's probably one of the intellectuals on the conservative side of the aisle, a textualist through and through. And as you can see at oral argument and some of the writing, his opinions can be sharp, but so is his mind. But he's a fair judge. His reputation in Miami has been phenomenal. He's a judge's judge. And if you do have oral arguments, be prepared on either side that you're on. He's going to ask very, very, very hard questions.
And Dwayne, did you want to talk a little bit about Judge Grant as well?
Sure. Judge Grant is also a new judge to the court of the 11th Circuit in Georgia. And we're waiting to see how she's going to rule in a lot of cases, as Judge Luck and many other judges who've been appointed. She also is a member of the Fellow Society. That is one of the common denominators that we have seen in a lot of the appointments. But what's interesting is that at least what I've noticed in my practice is that has not been always the indicator for how the judges will rule. What we're seeing in some instances, and one of the cases we'll talk about today, is that even judges who were on the same sort of ideological view as far as judicial interpretation, you see schisms and differences. And I've seen that as well. I've argued a case in front of the judge, and so I can say that from experience.
Freddy, do you want to talk about some of the other judges?
Sure. First, I'd like to start with Judge Lagoa, who has, she started, well, I mean, before that, she was an assistant U.S. attorney for the Southern District of Florida for about 3 years, from 2003 to 2006, when Governor Bush appointed her to the 3rd District Court of Appeals. She was a judge there for quite a bit. She was even chief judge. And then in 2019, Governor DeSantis appointed her to the Florida Supreme Court. And very quickly after that, same year, President Trump nominated her for the 11th Circuit Court of Appeals to take over the seat that used to belong to Judge Stanley Marcus, who was appointed to the 11th Circuit by President Clinton. I've argued in front of her. She is a very nice judge. She, even when she disagrees with you, she's very polite about it. She doesn't have too much of a track record so far on opinions. I think sort of the most sort of maybe ideologically charged one is Florida versus Department of Health and Human Services, where the 11th Circuit ruled that the Department of Health and Human Services could require anyone providing services, any hospital providing services to Medicare or Medicaid patients, to have staff that were either vaccinated against COVID or that had some sort of legally valid exemption. And she dissented in that case. And then I would also like to talk a little bit about Judge Andrew Brasher. He's a Harvard Law graduate. After that, he clerked for now Chief Judge Bill Pryor in 11th Circuit Court of Appeals. And after that, it was sort of a meteoric rise for him as well. He joined in 2011 the Solicitor General's office in Alabama as a deputy Solicitor General. 3 years later, he was made the Solicitor General of Alabama. And 5 years after that, he became a federal district court judge after President Trump nominated him for a seat in the Middle District of Alabama. And less than a year later, President Trump nominated him for the 11th Circuit, where he has taken the seat that used to be Judge Ed Carnes' seat. I've never argued in front of Judge Brasher, but I have seen some of his oral arguments. He seems to be a very thoughtful guy who seems to look at the record and sort of think about the issues deeply. And he too has a very short record in terms of writing. He did have in a very interesting case, which was unpublished, but oddly enough for the 11th Circuit, Judge Martin wrote the opinion for the majority, Judge Luck dissented, and Judge Brasher actually wrote a concurrence agreeing with Judge Martin and explaining why he thought Judge Luck was maybe wrong. He too, in his short stint so far, has written a decent amount of concurrences, so I think he might be an independent thinker.
Tania, do you want to tell us about Judge Branch?
Yes. So Judge Branch was President Trump's second appointee to the 11th Circuit and replaced the Clinton appointee Frank Hall. She, I think, is considered one of the most conservative of the new judicial appointees. Her background was in private practice predominantly, and then she had a short stint in the George W. Bush administration as a regulatory lawyer for about 4 years. When she returned to private practice, she was nominated to the Georgia Court of Appeals, and she served there for about 5 years before joining the 11th Circuit. She has described herself or sort of talked about admiration for Justices Scalia and Thomas, and is sort of in that mold, describes herself as an originalist and a textualist. She's also was a Federalist Society member, and in fact, before joining the State Court of Appeals, she was on the executive board of the Federalist Society. I will flag some of the concerns that were raised about her nomination before she was elevated to the 11th Circuit, and those included things like skepticism of substantive due process, a narrow view of privacy rights, and a hyper-technical construction of terms that could give them really narrow meaning, and that could be to the detriment of plaintiffs in civil cases. It could be to the benefit of criminal defendants in criminal cases. I think her textualism is a place to watch, and it's kind of interesting in the context of one of the cases we're going to discuss today, textualists versus textualists, and sort of where those kinds of questions land, and where they can kind of be pushed when bigger picture concerns and sort of looking at statutes and objectives more broadly kind of give different meaning to terms than they might otherwise get. One of her most controversial cases has been in voting rights. Since she joined the 11th Circuit, that was Alabama versus NAACP, where she dissented, arguing that Congress did not abrogate states' immunity under the Voting Rights Act. And it's sort of outside of the mainstream, I suppose, is one way to say it, where every other circuit that's considered the issue has come out the other way. Judge Wilson wrote the majority for that panel. So that's, I think she's going to be a really interesting one to watch. She has been on the court for several years now. I've not appeared before her. She's a strong writer. I think it will be really interesting, like I said, to watch where her textualism leads her.
Well, Erwin, there's two interesting characteristics that I wanted to talk to you about. Once, of these 6 judges, all of them are fairly young. The youngest is about 40, and the oldest is only 54, which is relatively young. And 4 of them were put on President Trump's list of potential Supreme Court nominees. So conceivably, if we have another Republican president, all 4 of them could be in the running for the next vacancy on the Supreme Court. How does the transformation of this court fit in with the larger trends you're seeing on the federal courts nationally? Oh, you're muted.
You'd think after 2 years I'd be better at that. Thank you so much for including me in the conversation. First, I think you're absolutely right to point to the age of the justices. Let me just take one example of this. Judge Brasher is 40 years old. Imagine he stays on the court until he's 80. And certainly conceivably he'd stay longer than that. That would mean he'd be a judge on the court until the year 2062. And you could do this for all of the judges and think about how long they are going to be there. And this is the pattern for all of the Trump appointees for the courts of appeals, the district courts, and the Supreme Court. I can do the same thing with regard to Justice Amy Coney Barrett. She was 48 years old when she was sworn in on October 26, 2020. If she stays on the court until she's 87, the age Justice Ginsburg died, Barrett will be a Supreme Court justice to the year 2059. It was clearly a plan of the Trump administration to appoint very young conservatives to the bench. I do think that those with ambitions for going to the Supreme Court will find that that affects how they write their opinions and what they decide. Lest you think that's just opinion, there was a study that was done by Richard Posner and William Landis and Lee Epstein, and they actually tried to come up with a measure of those Court of Appeal judges who might be seeing themselves as auditioning for the Supreme Court and how it affected their decisions and their opinions. And since they're going to be trying to appeal to a conservative Republican president, it might very well push them further to the right in how they vote and what they write as opinions. Finally, in answer to your question, I think there is a real shift in terms of judicial conservatism. If we have been having this conversation, say 30, 40 years ago, judicial conservative was defined as deference to the government. It was about judicial restraint is defined by respecting precedent, defined by deferring to the elected branches of government, defined by ruling narrowly rather than broadly. Now there is no pretense for judicial restraint among the conservative justices on the Supreme Court or among the conservative justices on courts of appeals. I think we're going to see it this year in the Supreme Court with areas like abortion and next term affirmative action, where you're not going to see judicial restraint in terms of deference to precedent. You're not going to see judicial restraint in terms of deference to the other branches of government. You're not going to see narrow as opposed to broad rulings. We're really at a time of quite aggressive conservative judicial activism.
It seems sometimes that the debate on some of these courts is really between the incrementalists and the judges who want to go a little faster and push a little further. But let me ask Tania about President Biden's nominee to the court, because Judge Martin did retire, and President Biden nominated Nancy Abudu of the Southern Poverty Law Center to fill her seat. You used to work at the Southern Poverty Law Center. Can you tell us a little bit about Nancy Abudu and her background, and what, if she's confirmed, she might bring to this very conservative court?
Sure, and I didn't get the chance to work with her at the Southern Poverty Law Center. We didn't overlap, but she was a colleague, certainly in Florida, and is a really interesting nominee and for what she can bring to the court. So just by way of background, Nancy's the daughter of immigrant parents from Ghana. She was born in Virginia and has spent most of her legal career in Florida and Georgia. So she did a stint at Skadden Arps in commercial litigation. She served 2 years as a staff attorney at the 11th Circuit. And then after that, she joined the ACLU's Voting Rights Project, where she litigated cases around the country on voting rights issues. She joined SPLC really to create a voting rights project there. And I missed a step in between. She was also the ACLU's legal director in Florida. So she has been a dedicated public interest lawyer for many, many years, both on civil liberties and civil rights issues, a broad array of cases and a lot of litigation experience. And she's, she would be the first Black woman to be appointed to the 11th Circuit, which I know we just went through this with the Supreme Court, and it seemed shocking at the time to say that this is the first Black woman to the Supreme Court, but even more shocking to say first Black woman to the 11th Circuit Court of Appeals. I think a lot about what professional experience brings to the bench and how important that diversity of view and experience, how important it is to the way judges talk about cases, to the way they talk about litigants, to the way they analyze issues. And I'm particularly curious to see how this might play out, between a Judge Abudu and a Judge Branch on something like voting rights. Some of these issues are, you see judges in their opinions sometimes kind of falling back on common sense on voting ID, common sense on bathrooms. And common sense really is nothing, it's just a proxy for what people see as their own experience, what seems like obvious to them. And so the more diversity we have on the bench and the more different experiences, and both professional and personal, I think the more we can kind of open that door to what really do we mean, what are these principles, which are legally defensible and which are not. And I would like to see us come back, if there ever was a place where we're having more sort of straightforward conversations about the principles of law, about conservatism, about deference, about factual findings, about how the system of law ought to work. And I think having a diversity of perspectives helps kind of siphon off some of these other things that can get in the way to get to those core issues.
And one of the topics maybe we can discuss and ground it in the first case we're going to talk about is what's the value of a judge who might be writing a lot of dissents, and how can someone like Judge Abudu, just like Judge Martin, influence or impact the court when she's in the minority? And I think that sort of leads naturally to our first of 3 en banc cases that we're going to talk about today. This is a fascinating case. I mean, we could probably spend the whole hour on it. It's Adams versus School Board of St. Johns County. And it's a challenge by a transgender student to the bathroom policy at his high school. Drew Adams was born as a female, but came to the conclusion that he did not identify as a female. And with the help of his parents and doctors, transitioned to become a male. He had the state of Florida change his driver's license to identify him as a male and other legal documents as well. And when he was in high school, he began using the men's bathroom at the high school. And for about 6 months, there were no complaints until 2 anonymous girls, not boys, complained. And the school said that he either had to use the girls' bathroom or he could use a bathroom in the school office. He sued, and there was a 3-day bench trial in front of Judge Corrigan, who's a George W. Bush appointee, and he won. And then it went on appeal. So Tania, if you could just tell us what happened on this appeal, which also went en banc.
Sure. So it is a really interesting case. And one of the things to me that's most striking about it is, what is the case about? So the district court said, everybody in this case agrees that girls should use the girls' restrooms and boys should use the boys' restroom. What they disagree about is whether Drew Adams is a boy. But when you get to the appellate decision, the dissent sees that very differently than the majority. So the majority opinion is about applying intermediate scrutiny to this classification, that there are a lot of levels to it. But just to close out the first point I was making, the majority opinion authored by Judge Martin is going through how is Drew Adams treated, and how is this question about his sex determined in which bathroom he is allowed to use, what's the impact on him. It goes through the district court's factual findings. The dissent says that the whole case is about whether there will ever be sex segregated bathrooms ever again. And again, kind of circling back to a point I made earlier, Judge Pryor and his dissent relies a lot on what he thinks is common sense and obvious things, that boys are boys and girls are girls. And there's a great footnote in one of the panel decisions where Judge Martin says, the primary issue with the dissent is that they don't grapple with the whole question of what does it mean to be a transgender boy? And I think that is spot on. So you have this real disconnect of conversation between what are we even talking about? And it gets back to some of these questions. The district court, Judge Corrigan, found that Drew Adams is a boy. And he went through, as he said, a trial. He looked at the science. He looked at the treatment for gender dysphoria that Drew Adams had undergone, the physical surgeries he had undergone, and that he was a boy. He was like any other boy. And that's kind of central. And I think this appeal raises the question of, what kind of deference does that finding get? And in the panel, in the majority decision, it gets a lot of deference. He's a boy. So now the question is he being treated fairly? The dissent doesn't buy that he's a boy. The dissent says he's a female who thinks he's a boy, basically. So you have a really central kind of conflict that, again, are we resolving it as a matter of fact and law, or are we resolving it on the basis of something else? So I don't want to miss any of the key points of the decision. I think the school board in its policy said, we're concerned about Drew Adams or any transgendered kid using the bathroom for the sex that they identify with because of privacy concerns of the other kids or safety concerns. And the reality was that although these concerns had been voiced, including by parents in the school district, there wasn't any evidence to back any of it up. Even the 2 girls that sort of reported, hey, Drew Adams went to this bathroom, there was nothing in the record that said, and they were afraid, or there was an incident. There was just nothing. There was no evidence put forward on either of those. So those turned out to just be hypothetical and conjectural concerns, not enough to justify this kind of a policy that would make Drew Adams have to go use a different bathroom, which, by the way, was farther away from his classrooms, which would require him to go past the boys' bathroom, obviously having to avoid it, which was like a walk of shame to him. It, signaled to him and to others that he wasn't considered a real boy. And I think, one of the other arbitrary things in the way the school applied this policy that became central to the majority decision is Drew Adams started at this school in elementary school. And when he first filled out his enrollment forms, his family marked female. And then in high school, he was transitioning and transitioned to a boy. And so he marked male. And the school district said, you just get this choice once. And whatever you said the first time is what we're going to go on. But if another transgendered kid showed up in high school and said, you know, I've transitioned, I'm male, they would get the benefit of being able to use the bathroom that corresponded with their transgendered sex. So, so there was an arbitrariness to that Drew Adams couldn't get the benefit of the same thing, and that the school board would rather credit outdated forms that no longer apply and not credit what the state of Florida is saying on its paperwork, what his driver's license says, and what Drew Adams and his doctors also say.
You know, Erwin, one interesting thing about this case is that Judge Martin had a much more expansive opinion for the panel, which was her and Judge Jill Pryor. And then the case basically sat in limbo. A judge held a mandate for quite almost a year. And then she wrote a second narrower opinion. And the theme of her, and she wants to go narrow and say this is just an as applied challenge for one kid. Whereas the dissent, Judge William Pryor, really is saying, no, this is a big issue. There's broader issues that we need to consider. And I'm going to discuss all of the broader points in the original panel. I guess I have two questions for you, Erwin. Why do you think one side is going small and the other side is looking at the case in a broader lens? And also, just as a strategic matter, what did you make of Judge Martin's strategy to withdraw her broader opinion and issue a second narrower one?
Those are great questions. In terms of the former, I think it's got to be put into the larger context. I think from the perspective of Judge Martin, or my perspective, this is about discrimination against a particular individual. This is about discrimination against a person for being transgender. And I think that Judge Martin wants to put it in that context. On the other hand, I think for the dissent, they want to put it in the context of a much larger culture war. This is about who gets to use what bathrooms. This is about what we should think about transgender individuals. After all, just a week ago, Alabama adopted a law that makes it a felony for a doctor to give to children things that would be puberty blocking drugs or to engage in gender reassignment surgery. And so I think that what Judge Martin and the majority are trying to do is say, think of this through the lens of discrimination against this particular person, and that gender dysphoria is real, and it's real for him. And I think Judge Pryor and his dissent wants to put this in the much larger context of the culture wars. In terms of the second, I don't know. I have to admit, I liked the first opinion much better than the second opinion. I think the first opinion made many important points. I really liked that towards the end of the analysis of the constitutional question, Judge Martin wrote about how the school policy was relying on sex stereotypes and overbroad generalizations about transgender students. I like that the first opinion emphasized, Tania just did, that there was no evidence here that there was any disruption or any problem with letting him use the boys' bathroom. I also like that the initial opinion focused on Title IX that prohibits educational institutions that receive federal funds from discriminating on the basis of sex. It relied on the Supreme Court's decision from June 2020 in Bostock versus Clayton County that said discrimination against transgender individuals is sex discrimination. The latter opinion is much narrower. The latter opinion focuses just on how irrational it is to rely on the records that were filled out earlier rather than the current situation for the student. Now, my guess is it involves a sense of the judges on the 11th Circuit that I don't have. That Judge Martin probably had some sense that if she wrote a narrower opinion on very limited grounds, it'd be more likely to stand up on en banc review. And I'm not in a position to be able to assess that. And obviously we'll only know when we see what happens.
No, that's right. It was a lively en banc review. we don't have an opinion yet, so we will see what happens. We're going to have to turn to the next en banc opinion where we do have a final opinion. This is also a fascinating case in Ray Wild that comes out of the Jeffrey Epstein sexual abuse scandal. As probably everyone knows, Jeffrey Epstein was a wealthy financier who would lure young women into his circle and sexually abuse them. And one of those women was the petitioner, in this case, Courtney Wild. She received a letter from the U.S. Attorney's Office here in Miami identifying her as a victim of Mr. Epstein's under a statute called the Crime Victims' Rights Act. And after receiving that letter, unbeknownst to her, the U.S. Attorney's Office entered into a non-prosecution agreement with Mr. Epstein, where he pled to some state-level prostitution charges and got an agreement not to be charged for the federal crimes that the federal prosecutors had been investigating. She was never informed about this agreement until she sued. And it was her lawsuit under the Crime Rights Victims Act, which helped her find out what had happened to the investigation and this deal that the U.S. Attorney's Office had entered. So the district judge actually ruled in her favor on the merits, but didn't give her any remedies. And then the case was appealed to the 11th Circuit. And Dwayne, why don't you tell us what happened once the case got to the 11th Circuit and what the issues before the en banc court were?
Sure. I think first you have to understand context about the Crime Victims' Rights Act. In essence, what Congress did is it created rights that victims of federal crimes have to be informed about hearings, to consult with federal prosecutors before major decisions are made. And the act explicitly said that if the Department of Justice or other employees are handling these sort of matters, whether it's the detection phase, the investigation phase, or the prosecution stage, they have to ensure that the rights of victims are protected. So here, she filed a petition, Miss Courtney Wild, filed a petition of mandamus in front of the 11th Circuit, in which she challenged District Court Judge Ken Mara's decision to deny her a remedy. At the time that the district judge denied a remedy, Jeffrey Epstein had died. And so some of the ideas of rescinding the non-prosecution agreement that the district attorneys didn't tell her about or the other victims about, those remedies kind of were moot at that point. There were other remedies that did exist. And just to add a little bit of flavor to what David said, it was not only that the Department of Justice attorneys didn't tell Miss Wild and the other victims of Jeffrey Epstein about the non-prosecution agreement, they lied about it. They had this agreement and they purposely told the victims that it was still an investigation. So it goes to the 11th Circuit. There's a panel of Judge Newsom, Judge Joe Flight, and Judge Hall. And in a divided decision, the 11th Circuit held that neither Miss Wild nor any other victims under this particular act had a pre-prosecution rights that they could enforce under this particular act. Now, of note, that ruling would have put the 11th Circuit at odds with the 5th Circuit that had ruled the completely opposite way. When the 11th Circuit took the case en banc, they managed to decide the case in a way to avoid a circuit split, but essentially ruled the same way and in fact curtail even more rights than the initial decision. In an en banc review, a divided panel of the 11th Circuit held that neither Miss Wild nor other victims of the Crime Victims' Rights Act have a right to bring, quote, a standalone lawsuit or standalone proceedings to enforce rights in the CVRA before an indictment or prosecution has begun. And that's a meaningful determination because under that particular act, crime victims have the right to be consulted, to have information, and to be treated with respect and dignity. And if those rights don't exist before indictment, then you may have a situation such as in the Jeffrey Epstein case once again, where you have these non-prosecution agreements that are conducted under the cloak of night that aren't disclosed, and the crime victims do not have a remedy in which to engage in that. What the majority opinion said in this case, which was written by Judge Newsom, who also wrote the initial panel decision, is, you know what, under our precedent, Supreme Court precedent, if you are alleging a statutory cause of action, it's got to be clear. If it's not clear, we're not going to allow it. And the court relies on textualism by analyzing the statute to conclude that Congress did not intend there to be a private right of action pre-prosecution. Of note, another conservative, another federalist reviewed the same exact statute, using the same exact textualist framework. In fact, both of them cited to Scalia and Garner's book of reading the law and reached completely opposite results. And what Judge Branch held there is that the act did provide rights pre-prosecution and that they were allowed to be remedied in a standalone proceeding. And what's of note, I think that Judge Branch points out, is the administrative remedy that the majority sort of hangs its hat on as an alternative. Part of the requirements for filing that remedy, which is through the Department of Justice, sort of an ombudsman, you have to file a petition. And one of the things you have to do is identify the court and the defendants being prosecuted. But pre-prosecution, you don't have that information. And so what she concludes, among many other things, is that really that's not a remedy at all. And so this is really a case. This is a tale of two textualists. And the question is, when you have these different forms of textualism, of canons constructions, which ones really control? Which ones are the dominant ones? If you talk to Judge Branch, I think what you would conclude is that what's most important is to give effect to all parts of the statute. The majority opinion, whether you think it's well-reasoned or not, it leaves certain parts of the statute inoperative, that just they don't have effect. The Congress saying that the Department of Justice, for instance, has to be protective of the rights of victims during detection, investigation, or prosecution, those first two items are, in essence, pushed off the table. And so that's sort of where we are. I'll make one other quick point before I throw it back to David. What's also of note here is that the textualist judges, and in fact, I want to be fair here, that Judge Wilson also joined the majority, and we also had a number of judges that recused themselves, so we really didn't have a full en banc panel here. But what's of note is the judges in the majority, Judge Newsom, Judge William Pryor, Judge Lagoa, and so on and so forth, they've relied on a lot of policy arguments in order to support their textualist viewpoint. And of note, Judge Luck did not sign on to a lot of the policy arguments. He signed on to certain of the textualist arguments. And so the question is, as Judge Branch raised, is, listen, if the statute reads a certain way, policy concerns really don't matter. And so this is why it's a very interesting case to get a sense of where the courts align, and even when justices or judges may be conservative ideology, they may be textualists, they may be Federal Society members, and use the same tools, they can reach vastly different results.
And that's an excellent point, Dwayne, because both the dissent and the majority are two very conservative judges, both saying they are relying on the text of the statute. So let me ask Erwin, and also throw this up to the other panelists. Is this case really a tale of two textualists, or is this a case about the court's concern about impeding prosecutorial discretion and limiting the power of federal prosecutors to have free rein to make charging decisions? What do you think, Erwin?
Yes, I think it's both. Undoubtedly, it is about textualism. And I think the lesson to draw here is, rarely are you going to find answers in texts of laws. Certainly there are statutes that are clear, but what so often you find is when judges say, we're going to just follow the plain meaning, they say, the statute says this, thus the plain meaning leads to the conclusion. And I read the statute and I say, well, it's plausible, but there's an equally plausible way of reading the statute. On the other hand, the textualism doesn't provide an answer. And I think you see that by reading the different opinions in this en banc. But I also think that what animates this is a view with regard to prosecutorial discretion and how much the majority is worried that a particular reading of the statute would interfere with prosecutorial discretion. So I don't think you can ever divorce the reading of the text of the statute from the underlying policies that animate the law and that animate the judges deciding the case.
You know, and let me ask Freddy or Dwayne, either of you all can weigh in. Do you think there's a third thing going on in this case, which is a concern of the court about creating new rights? I mean, this statute is pretty novel and it creates rights that had not existed before. Is what we're seeing here a reluctance of courts to recognize and give full power to new statutory rights?
I mean, absolutely. I'll be brief. You see that actually in Judge Newsom's opinion, he comes right out and says it. Well, if you have this situation where a crime victim can come into court before the federal government has decided to exercise a prosecutorial decision, well, then the judge is going to be in a position to determine, well, are you a crime victim? What was the crime? What were the rights that were affected? And I think one of the underlying sort of policy issues that sort of go unspoken is the court is concerned about how to deal with this. How do you decide these questions? What is the level of discretion? What is the level of deference to the prosecutors? And I think they're also thinking about themselves. Well, what do we do on appeal? How many of these cases are we going to get? And so I think that's certainly a big part of it, of what's going on here.
Yeah, I absolutely agree. I mean, Judge Newsom's majority opinion on this, I mean, he hits that hard. He makes that clear, and he even points. One of the arguments made by the petitioner is by Courtney Wild was there's language in the statute that says that there's nothing in this statute should be construed as providing a cause of action to recover damages. So it must mean you can recover something else. And Newsom, I mean, he was just like, well, absolutely not. Just because it says you don't have that doesn't mean it means the opposite, that you do have something. But her reading I thought was sort of natural. When I first read that, I almost absolutely, I'm like, okay, well, that must mean she has some right to injunctive or equitable relief of some sort. But Newsom's opinion seems to suggest that if Congress wants to create a cause of action, at least in 11th Circuit, it better specifically say so.
Tania, when we were talking about Nancy Abudu's nomination, you talked about professional background. And one thing that stood out to me is, other than Jill Pryor, who was in private practice before she joined the bench, all of these judges have either worked for a U.S. Attorney's Office, for the federal government, or for a state attorney general. Several of them were solicitor generals. Is that just kind of a coincidence that of their background, or do you think that impacts their concerns about prosecutorial discretion and their reading of the statute?
I mean, in my view, there's no question that has an impact, because your experience makes how you see things. I mean, I don't say it's determinative necessarily, but I will note the irony when you've got judges who might otherwise go on about judicial restraint, right? And about separation of powers and about all of these things. We're not the policy people, right? We just apply, enforce, interpret the law, and then sort of go off that rail. So I think it's very interesting. I think it's definitely a tension. And I think it's reasonable to look at the backgrounds and say, this might be informing your view, and maybe also bringing in some considerations that you might not otherwise have given so much weight to, had you not lived that life that you led.
I mean, Erwin, is that fair? I mean, you certainly hear criticisms of that on the right, that it's not about biography, it's about the statute.
I think that's nonsense. I think that we've got to recognize that judges at a Court of Appeals level, at the Supreme Court especially, but even at a district court or in the state court, often have discretion. Of course, there are easy cases where any judge would come to the same conclusion. And there are all sorts of cases where the judge's ideology and background doesn't make a difference. But there's so much discretion in being a judge, and the way the discretion is exercised is inevitably a result of the judge's ideology, the judge's own personal life experience. All of us argue cases in the courts of appeals. Don't we want to know who the panel is as soon as we can find out? In the Ninth Circuit, you find out your panel the Monday, the week prior to the argument. I'm up that morning to look up and see who the panel is. And I've looked at panels, I'm sure you have, and I know sometimes I look at it and go, wow, unless I really mess up, I should win this case. And there's panels where I say, I could let my puppy go argue this case, and I have no chance. That's because we know who the judges are matter. Why did the Republicans fight so hard to keep President Obama from putting Merrick Garland on the Supreme Court? Why did the Republicans fight so hard to rush through Amy Coney Barrett? It's precisely because they know that who the justices and who the judges are matters enormously. Why did they not randomly pick other individuals equally qualified to those that President Trump put there? Why did he want Federalist Society individuals who were hard right conservatives? Because he knows it matters. So it just seems nonsense for President Trump to pick these individuals and for them conservatives to say, oh, it doesn't matter who's on the bench.
I think, we should probably turn to the third case, which is another en banc case, and it's a standing case. Although, like the first case, we could probably spend, another 30 minutes on this case. But in the interest of time, we should move on to the standing case, which is Hunstein versus Preferred Collection and Management Services. This is also a case that was argued en banc in February, and we don't have a final opinion from the court out yet. And this is a case under the Fair Debt Collection Practices Act. So what happened here was the plaintiff, Richard Herstein, had a debt from All Children's Hospital in St. Petersburg, Florida. And the hospital assigned the debt to a company, Preferred Collection and Management, who then hired a mailing vendor, CompuMail, to take care of this collection. Well, in doing that, Preferred transmitted information about the plaintiff, about his debt, about the fact the debt was for his son's medical treatment, about the amount of the debt, to this third-party vendor. And he sued, alleging that that was a violation of a provision of the Fair Debt Collection Practices Act. So Freddy, why don't you tell us what happened in that lawsuit and when it got to the 11th Circuit?
Sure. So as David mentioned, the Fair Debt Collection Practices Act basically makes it a violation for a debt collector to communicate someone's personal information to third parties, with some exceptions that are not relevant here. And those were exactly the allegations, not just, by the way, the fact that his son received medical treatment, but apparently the son's name was disclosed to this vendor and the vendor's employees. And the case went in front of a panel of Judge Jordan, Judge Newsom, and Senior Judge Joe Flatt. And they originally all agreed that there was Article 3 standing here. It was a very short analysis. And then the United States Supreme Court issued the opinion of TransUnion versus Ramirez. And so the case was sort of reevaluated. And this time, Judge Joe Flatt changed his mind. And so we get a much more robust sort of analysis about Article 3 standing and whether the type of harm that Mr. Hunstein suffered here under the Fair Debt Collection Practices Act is the sort of harm that gives Article 3 standing. And Article 3 standing, as currently sort of manifested in the law, is a very layered thing, right? It has first is injury in fact, causation, redressability. Injury in fact has some sub-elements. One of the sub-elements is concreteness. And concreteness itself has even more sort of options of how you could show that a harm is concrete. And everybody seems to agree that in this case, Mr. Hunstein would have to show that his harm, even though intangible, was nonetheless concrete. And there is a test for this. First, you have to look at the history. We have to see whether the harm alleged in the complaint is in close relationship to the harm traditionally recognized by the law and by courts. And then there's a second aspect that's not that much of an issue here about Congress's judgment. But really, this case is sort of, Judge Newsom wrote the majority opinion. Judge Jordan agreed and joined it. It's really it's interesting because Judge Newsom is a very sort of informal writer, and it's clear that he's sort of struggling to sort of explain whether this type of harm is close enough to the common law tort of invasion of personal privacy. And ultimately, Judge Newsom concludes, look, what matters is this violation of the Fair Debt Collection Practices Act in kind, like invasion of personal privacy. And he says, yes, I mean, there's a publication-like element in the sense that there's a communication to a third party. And the harm is, that there's a disclosure of facts that are in a sense private and personal, the name of your son, and what that son got medical treatment. And so he thinks, and he's really sort of struggling with the dissent's sort of issues about, well, the publication here was only to the vendor and the vendor's employees. It's not like they went to Times Square and sort of just disclosed all the information. But Newsom's basically retorts, he responds, okay, but how many employees is enough? If he had disclosed this to one employee, okay, maybe that's not enough. But if it's 5, 10, 50, 1,400. And so he's like, once you start talking about that, you're talking about degree, not kind. And he's like, and ultimately he's saying, maybe I don't know what case or controversy means under the United States Constitution in Article 3, but it cannot be that we as federal judges have to sort of sit here and decide how many employees finding out this information is enough for there to be standing. And so he ultimately concludes, if you just look at it in kind, these things are very similar. There's Article 3 standing here. Judge Joe Flatt disagrees. And his dissent is ultimately, he says, there is no publicity here. The number of employees, we don't know how many employees got this, but it's just not the same as going into the public and sort of disclosing this in a newspaper article or online or anything like that. So as David mentioned, the panel or the court held this en banc in February. I listened to the oral argument, and it's just sort of clear that Judge Newsom and Judge Jordan just really can't believe that Article 3 standing is sort of requiring courts to consider, well, how many employees hearing this communication is enough for there to be Article 3 standing under the US Constitution. That being said, it's not clear to me after hearing the oral argument who's going to prevail. It looks like Chief Judge Pryor and Judge Grant agree with Judge Joe Flatt, and obviously Judge Jordan and Judge Newsom agree with themselves. So we'll see how this comes out.
Erwin, I wonder if I can ask you to sort of put this case in the broader context of standing, which obviously is an issue that the Supreme Court has been developing for some time, and get a sense of where this fits into the broader standing doctrine. Is it closer to what Justice Thomas wrote in his dissents in TransUnion, or is it more like what Chief Justice Roberts, what some of his opinions have been like in this field?
What this is about is that the law has traditionally been that Congress by statute can create a right, including a right that wouldn't otherwise exist, and the infringement of that right is sufficient for standing. And there are many Supreme Court cases that said explicitly what I just did. Congress by statute can create a right, and the infringement of that right is an injury sufficient for standing. The TransUnion versus Ramirez case from last June is important because Justice Kavanaugh, writing for the majority, says it's not enough that Congress by statute has created a right. It has to be a right that's closely analogous to one that existed in common law or historically. Otherwise, the infringement of that right doesn't give rise to an injury sufficient for standing. And as you rightly point out, none other than Justice Thomas joins the 3 liberal justices in dissenting. Well, the implications of TransUnion versus Ramirez, it's taken literally, are enormously important. Think of the Federal Freedom of Information Act. It gives every person a right to all documents possessed by the federal government, unless they fit in one of 9 categories of exemptions. It creates a statutory right that wouldn't otherwise exist. And it's always been assumed that the infringement of that statutory right is sufficient for standing. But it's not a right that's closely analogous to one that existed historically at common law. Does that mean that people no longer have standing to sue under the Freedom of Information Act? Or take Title II of the 1964 Civil Rights Act that prohibits hotels and restaurants from discriminating. Tragically, that's not a right that existed historically or at common law. Does that then mean that an infringement of Title II is no longer sufficient for standing? I could go on and on with examples. And this is one of the first cases that will come to an en banc court to try to analyze how do you determine when a right is closely analogous to one that existed historically or at common law? And that's what they're arguing about here. And that's why it matters so much.
Let me throw this question out to the panel, to Freddy, or to anyone else who wants to jump in. Is there any danger of weakening the standing doctrine so much that you can sue, as apparently you're able to do in Texas under their new abortion law, simply because something has happened that you oppose, you think is immoral, but isn't personally affecting you? Are we in danger of having the Supreme Court sort of loosen the standing doctrine too much so that you could get these citizens suits like we saw in Texas with their abortion law?
It seems to me we're seeing two different dynamics at play. One is the tightening of the screws on the US constitutional level, and then the blowing the doors open at the state level. So it's sort of two diverging trends that are troubling in their own way. One is shutting the courthouse doors to a lot of people, and the other is opening them on some very odd, sort of unprecedented grounds.
And another thing to keep in mind too is whether or not the law should be allowed to grow and develop. If we have this mindset that we have to look back in time to the rights that existed at the founding or common law, does that constrain Congress's ability to recognize new rights, new protections that it wants? And if we're going to apply textualism and be faithful to it, what would be the harm in doing so? These are all questions that should be discussed, should be analyzed, because maybe the theories that we're relying on are not sufficient to meet some of the current views from Congress as to what things they want to protect and how.
And bouncing off a little bit of what Dwayne just said, Judge Jordan on the en banc argument, he sort of made a great point, which is, if the whole point of this analysis is that we're supposed to look back at the founding of the Constitution, why are we looking at all at the restatement of torts, a 20th century creation, or invasion of personal privacy, which is also a creation of the late 19th century? I think it just sort of shows his frustration, just Newsom's frustration, that this entire sort of legal structure on Article 3 standing seems pretty arbitrary, especially when you're doing what TransUnion did, which is saying Congress no longer has sort of the right to create a right through a statute. That is not enough.
We have one question, which might be a good one to end with in the Q&A. I'm going to read the question and then I'm going to kind of tinker with it and change it a little bit. So the question reads, of the judges appointed by Democratic presidents, I believe Judge Wilson is the only judge eligible to take senior status, which is true. I'm curious, is there any push for Judge Wilson to go senior and allow President Biden to appoint a successor? So I'm going to change that question a little bit. I don't know if there's a push or not. In my experience, you don't push a circuit judge. They're going to do what they want to do. But let me change that subject, which is, why is it that the Republican president, particularly under President Trump, was so effective in filling court seats? And why were there so many circuit judges, particularly on the 11th Circuit, who happened to retire during his presidency? And by contrast, why hasn't the Democratic Party and President Biden sort of taken a page from that playbook? Erwin, let me start with you. This is more of a political question than a legal question, but interested in your thoughts.
In general, I think Republicans have cared much more about the judiciary than Democrats have. And as a result of that, the Republicans are much faster in appointing judges. Republican Senates are much faster in confirming judges. And so I think you see that imbalance reflected throughout the court. I think Republican presidents have generally tended to pick judges further to the right, and Democratic presidents tend to pick judges more from the center. Now, with regard to Judge Wilson, I obviously don't know, but 3 judges on the Ninth Circuit, Judges Berzon, Paez, and Fletcher, all Democratic appointees all quite liberal, took senior status very early in the Biden presidency to let Biden pick their replacements and get them through the Senate. Remembering, of course, if the Republicans take the Senate in November, then come January when they have control, no Court of Appeals judges, no Supreme Court justices are going to get through.
That's right. Any other thoughts from the panel on that point?
Yeah, I mean, look, as to the first question, I think that it's the reason President Trump got so many nominees, or the ability to put in so many nominees, is because of the legacy of the blue slip. Ultimately, Georgia, Florida, and Alabama are very conservative states. And so even someone like President Clinton or President Obama had to pick either center right judges like Judge Marcus, or frankly, judges who are very conservative like Judge Frank Hull, or just a mainstream conservative like Judge Julie Carnes. And so what happened is even the Democratic presidents are selecting essentially conservative judges. And then when a conservative president comes to power, those judges take senior status. And now all of a sudden Trump has 6 seats to fill instead of what would normally would have been 3.
Well, it'll be interesting to see over time how the elimination of the blue slip changes the compositions of the courts. With that, we're 1 minute over, so we're out of time. Just a few housekeeping matters. I wanted to make a plug for the American Constitution Society's National Convention. It's going to be held in Washington on June 16th through the 18th. And Justice Sonia Sotomayor is going to be the headline speaker. And then the all-important information about CLE credit. The CLE number for this presentation is 2202691N. Let me say that again, 2202691N. And it's also in the chat box. And if you didn't get that and need it, just send me an email and I'll send it to you. I want to thank the whole panel for attending. And everyone have a great day.
Thank you.
Thank you for having me.
Bye.